What is the Erie Doctrine? The Erie Doctrine is a fundamental principle in U.S. civil procedure that determines when a federal court, sitting in diversity jurisdiction, must apply state law instead of federal law. In simple terms, it answers this question. When a case is in federal court because the parties are from different states, should the court apply federal rules or state rules? This doctrine comes from the famous Supreme Court case, Erie Railroad Co versus Tompkins, decided in 1938. Before Erie, under the earlier decision of Swift v. Tyson, 1842, federal courts applied what was called federal general common law in diversity cases. This allowed federal judges to ignore state court decisions and create their own rules. The result was inconsistency and forum shopping, where parties would choose federal courts simply to get a more favorable law. In Erie, the Supreme Court overturned Swift. The case involved Harry Tompkins, who was injured by a passing train while walking near the Erie Railroad tracks in Pennsylvania. He sued in federal court, hoping to benefit from a federal common law rule more favorable to him than Pennsylvania state law. The court, however, ruled that there is no such thing as federal general common law. Instead, in diversity cases, federal courts must apply the substantive law of the state where they sit, including state statutes and state judicial decisions. The Erie Doctrine has two key principles. No federal general common law. Federal courts cannot invent general rules of decision in diversity cases. State substantive law applies. Federal procedural law applies. This creates the need to distinguish between substantive and procedural law. Substantive law, like rules on negligence or contract interpretation, must come from the state. Procedural law, like the federal rules of civil procedure, can be applied by the federal court. But the line between substantive and procedural law is not always clear. That is why Erie has generated decades of debate and additional cases, such as Guarantee Trust Company versus York, 1945, which introduced the outcome determinative test, and Hanna versus Plumer, 1965, which clarified that valid federal rules of civil procedure generally apply, even if they affect outcomes. An example. Imagine a contract dispute between a company in Texas and a company in New York, filed in federal court under diversity jurisdiction. If the issue is how to interpret the contract, the federal court must apply state substantive law, say, Texas contract law. But if the issue is how to serve process or the deadline to file a motion, the federal court follows the federal rules of civil procedure. A curiosity is that the Erie Doctrine, while technical, is one of the most important topics in U.S. legal education. It sits at the intersection of federalism, judicial power, and fairness, ensuring that litigants cannot manipulate the system by choosing federal court just to escape unfavorable state laws. In short, the Erie Doctrine guarantees that diversity cases in federal courts respect state substantive law while maintaining uniform federal procedure. It is a cornerstone of American civil procedure and a constant reminder of the balance between state and federal authority. Up above, I left you more videos so you can keep learning law. Don't forget to like and subscribe.